Hey, welcome to Disability Law Show. John Scholes once again, and this week, James Fireman alongside. Lots of information coming at you over the next 30 minutes, so make sure you pay attention. And I know we throw it up on the screen all the time, but I'll give the contact information off the top. 1-855-821-5900, the phone number, toll free, of course, and help at disabilityrights.ca. And on the show today, 3 things our lawyers do immediately for you after you hire us to fight your LTD insurer. That is on the way, James, in just a bit. But first, the week that was something that's been happening on your end this past week or two. What's going on, pal?
Well, one of the things that a lot of our clients are concerned about is what happens when they start a claim. And if they start feeling better, are they able to go back to work? And it's something that we discuss periodically. And the answer very clearly is yes. If you start a legal claim and at some point before the claim is resolved, you're able to return to work either completely or partially, then you are certainly able to go back to work, and in fact, you should. Because if you are able to earn 100% of your income, that's always going to be worth more than trying to get 2/3 of your income and then having to pay legal fees on top of that. So the answer is very certainly yes. The case I want to talk about today concerns that particular issue. Somebody who started a legal claim because they were denied their LTD benefits and went back to work. And so I'm going to discuss what happened in that particular case. This particular client was a teacher for a very long time, and we deal with many claims from teachers. Especially in Ontario, we probably have maybe a dozen or 20-odd cases at any given time with teachers in Ontario who've been denied their LTD claims. And so what happened in this particular case, she was denied several years ago, and rather than bringing a claim right away, she went back to work. And so she was back to work at a 50% pace. Initially it was 25%, but then she went back up to 50. She wasn't getting her benefits, so before her 2-year limitation was up, she hired my firm and we brought a legal claim. And so what happened was, because she was working 50% of the time, the way each policy works is a little bit different. And so we talk about long-term disability claims and a standard long-term disability claim. But one way that most claims can vary is how they treat income that you earn on a part-time basis. If you're cut off or you are getting LTD benefits, what happens to the income that you're earning? So in some policies, every dollar that you earn is just going to be $1 less that you're able to receive down the road. But in some cases, there's a complicated formula. And we're not going to talk about how it works, but usually the way the policies are set up is in a way so it's encouraging you to try to go back to work, so that if you're successful, overall you'll be getting more money than if you were just receiving your disability benefits. And that's to the benefit both of the claimant and of the insurance company. You want to be able to get more money, and they certainly want to encourage you to get off of claim so that they don't have to pay benefits. And so that's exactly what happened in this case. This client of mine, she went back initially 25%, then 50%. And eventually what happened is she wasn't actually able to go any further. Things actually got worse for her, particularly when the pandemic started. And so what we were able to do is we were able to bring a claim, and we were able to get her a significant amount of money as a result of that. And so she was able to not only maximize the amount of income she was earning while working on a part-time basis, but she was still able to continue with her legal claim. And that's something that's instructive for anybody out there that's concerned about what's going to happen if they start a legal claim. You certainly can go back to work and continue working, whether it's on a part-time or full-time basis. You have to do always what's going to be in your best interest. It's not about maximizing your legal claim. It's about doing what's going to be best for you.
PocketEmploymentLawyer.ca. I want to mention that, James. I know it says employment in the title, but there's actually a pretty robust section on disability law there as well. PocketEmploymentLawyer.ca, because James works so closely with employment lawyers. In fact, you're in the same firm. And there's a lot of crossover between the two quite a bit. So if you're currently dealing with a disability claim, maybe your insurer, maybe your employer is getting involved at the same time, go to PocketEmploymentLawyer.ca and read up on the stuff there under that section. If there's not enough, you can reach out to James or a member of the employment side, and they'll take it from there. But again, PocketEmploymentLawyer.ca. Want to get to James an email, I believe. Help at Disability Rights is how you reach out to this one. Email today, first one's from Ibrahim. He says, my brother injured his back a few years ago. He was able to work for a while, but in limited capacity. When he became depressed, his doctor told him to take a sick leave. He was put on short-term disability, but was denied long-term, as the insurance company said it was a workplace issue. You love the last part. Can we appeal?
Well, you can appeal, but I would advise you not to do that. Right. And this is something that if you've watched this program or listened to any of the radio shows that we have at any point in the past, you will have heard this advice. Don't bother appealing. It's a waste of your time. The only time it makes any sense to attempt an appeal is if at some point you uncover new information about what's causing your disability and the insured does not have that. And when I say new information, I don't mean a slight change in the circumstances. I mean something that completely changes the game. If that happens, it's worth at least taking a shot. And even if the insurer doesn't reinstate your benefits, at least then you can say you gave them the opportunity to do it. But except for that scenario where there is completely new information, appealing is just going to be a waste of time. Now, there are a couple other issues that Ibrahim's email really brings to mind. One is that his brother was initially on short-term disability benefits, and then when he applied for long-term disability benefits was cut off. And so presuming that this is the same insurance company, and I think it was in this case, it raises a question because typically speaking, the test for disability benefits is substantially the same, whether it's short-term or long-term. There are some differences on the edges, but they don't really get to the heart of whether or not you're disabled and whether or not you pass the test. And so if it's the same insurance company applying the same test, then they ought to come to the same result, unless by sheer coincidence, a miraculous coincidence, his brother happened to stop being disabled on the very day long-term disability benefits kicked in. But I would be pretty shocked if that were the case, and that would be a pretty difficult position for the insurance company to justify. Now, the other issue that's raised here is the workplace issue. And so what that really is referring to is a situation where somebody has a difficult supervisor or manager or other coworkers that they don't get along with, and as a result, it makes it an unworkable environment. Not necessarily a disability, but it's the environment itself. And so when that happens, the test is really this. The test is, would you be able to do your occupation for a different employer in reasonable circumstances? If your supervisor was more reasonable, if your coworkers weren't out to get you, if you were surrounded by your best friend and puppies, essentially, is the way one of my colleagues likes to put it. And that's about right. If you would be able to do your occupation somewhere else in reasonable circumstances and you would be able to do it, then you're not entitled to benefits. It is not difficult workplace environment insurance. It's disability insurance. But I don't get the sense that that's what's happened here. And the reason I don't is very simply because his brother was approved for short-term disability benefits. If his disability was a result of a difficult workplace, he shouldn't have been approved for short-term benefits. And presumably, when the insurance company looked at the claim for short-term benefits, they would have analyzed whether or not there was a workplace issue or a disability. And obviously they came to the conclusion in this case that it wasn't a workplace issue, that it was a valid disability. So I don't see how that's going to be any justification for them at all.
Coming up here after a short break, we're going to take a look at 3 things the firm will do for you immediately after you hire them to fight your disability law insurer. That is on the way. In the meantime, that phone number, 1-855-821-5900, help@disabilityrights.ca. We'll be right back. It's a Disability Law Show.
People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca.
And welcome back. Disability Law Show. John Scholes and James Fireman. As mentioned before the break, we're going to talk about this 3 things the firm will do for you immediately after you hire them to fight your LTD insurer. And number one is number one for a reason, James, and that is they take over all communications with the insurance company, which is just a beauty.
Yeah, so it's a common fear for a lot of people that starting the legal process is going to be really stressful. And it's actually the exact opposite. What happens as soon as you retain our firm to take over your case, all communications from that point forward go through my office. So that means you're not going to be hearing from the claims handler anymore. They're not going to be calling you up at home. They're not going to be asking you to go and get this document or do that. They're not going to be telling you that you have to go for this treatment or to see someone for this assessment. Everything is coming through my office, and anything that needs to get done in order to move your claim forward is going to get done at my office. We will get all the documents for you. You're not going to have to do anything other than sign an authorization that allows us to do that for you. So it's a very simple process, as it turns out. And what it actually does is it frees you up to focus on your treatment and rehabilitation. And when that happens, what a lot of people find is it allows them the opportunity to really put the stress and aggravation of dealing with the insurance company, which for a lot of people is really triggering them and making their situation worse. You can put it off to the side and you can focus on getting better, on doing what your doctors are telling you you need to get done in order to treat your disability. So in fact, the process itself can be very beneficial for a lot of people. It is not labor intensive, particularly from the claimant's point of view. Now, that doesn't mean you won't know what's going on. Anytime there is a significant development, we will certainly let you know that. And if you want to be more involved and find out more, we are always available to discuss your case 24 hours a day. So it's not something that you're going to have to be concerned about on a day-to-day basis. It's not something that you're going to be living with, that fear, that intimidation that most people feel when they're trying to take on an insurance company on their own. That instantly disappears the moment that they sign the retainer agreement.
Does that include something like if they ever have to go for a medical examination or an update, they have to go through you first and then you tell the client, look, you got to go see your doctor, so on and so forth?
It's really, really rare that once we start the legal process, our clients are sent to get an assessment either from us or from the insurer.
Wow, okay.
Typically by that point in time, there's already enough information there from the treating doctors. Now, I won't say that it never happens, but it's unusual. It is an exception, not the rule.
Number two thing you guys do right away is ask for the complete file from the insurer, which is good.
Yeah, so this is where we really make our money. This is where we set ourselves apart and why it's really important that you hire an experienced disability lawyer to handle your claim. So as soon as we're retained, as you mentioned, we're going to write to the insurer and we are going to ask for their entire file. And we go through that thoroughly, page by page. And what we're trying to figure out is what the insurance company knew and when they knew it. The reason this is so important is because if we've been retained, it means that that person's doctors are of the view that they are not able to work. Their treating doctors have said that. And if their treating doctors are saying that, that's who I am going to believe. If the insurance company has come to a different conclusion, then I believe they are wrong. And so I go through that insurance company, that insurance file, to figure out how they got the decision wrong. What was their process? So was the process itself fair? Did they look at everything carefully? Did they look at all of the information provided to them by your doctors? Did they ask for medical assistance from someone who's qualified to advise them on it or not? Oftentimes they don't. And so really what I'm trying to figure out is how they got the decision wrong and whether it was fundamentally unfair. And in doing that, what I'm going to do is I'm going to have a list of 5, 10 different things where the insurance company has cut corners or done something that's clearly designed to get to the decision that they wanted to get to. And in doing that, I'm going to set that all out at mediation. And I'm going to let the insurance company know that that I'm onto them and that if this goes to court, this is all going to come out and be in the public domain, and they don't want any part of that. So that's why getting the insurance file and going through it in a very thorough way is so critical.
And if the insurance company keeps building this file, like, in an ongoing process in real time, I guess, for lack of a better term, do you get that as well? For instance, if they schedule some surveillance, do you get every single second of that surveillance as they take it and it's used?
Well, it depends with surveillance. The law is a little bit complicated on that.
Right.
But if they do get surveillance, we will find out about it. The thing is, for the most part, surveillance doesn't happen. It's still pretty unusual. And when it does happen, it's so rarely going to hurt your case. If you have a legitimate claim,
sure,
then surveillance doesn't matter anyway. So I'm never concerned about surveillance. And usually I find that once I actually get the surveillance itself and I see what the investigator has found, it's usually quite helpful. Usually what you find out is that the investigator spent somewhere between 50 and 70 hours following my client around, and all they have is they're going into a drive-thru to pick up coffee once or twice during the week, and that's it. And if that's what the investigator finds, there's probably no better evidence that my client is disabled and is really not able to do anything. So I'm never typically concerned about surveillance. If they do get an assessment, which again is an exception, not the rule, if they do get an assessment, they do have to produce that to us. But otherwise, there isn't a whole lot that once we start the legal claim, the insurance company is going to get that I won't already have.
And you just mentioned the third one, which is starting the legal claim. That's the third thing you guys do, right?
Yeah, and so that is obviously something that's really critical. Again, if you watch this show with any consistency, you know that that's a really critical step. And I'm going to get into this a little bit more in the second half of this show when we talk about the power imbalance, but that's really what this is all about. Before you start a legal claim, when you're dealing with the insurance company on your own, this is typically $1 billion corporation that has tons of experience, that is making up the rules as they go along, and that gets to make all of the decisions with no one watching over their shoulder. You can bet there's a big power imbalance there, and they're going to lean on that. They're going to leverage that for all it's worth and make you feel small and make you feel like it's impossible. But here's the secret. As soon as you start the legal claim, everything changes. Everything flips. They have to play by the rules of the legal system. They don't get to make them up on their own. And it turns out that once you start the legal claim, the file gets assigned to an insurance lawyer. And they are typically very overworked. They have way too many files, and they don't have nearly enough time to dedicate to each file. Not nearly the time that I have and the other lawyers at my firm have, that's for sure. So if there is a power imbalance once you start a legal claim, it's actually going the other way. It's actually in favor of our clients, not in favor of the insurer.
Coming up here after break, the independent medical assessment. Ah, yes. Do you have to attend it? We'll check that box when we come back. In the meantime, 1-855-821-5900 to get a hold of James and the crew, and help at disabilityrights.ca as well for an email. We'll continue. Disability Law Show. Stick around.
People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back. Disability Law Show. There is another resource I want to mention as well for you, absolutely free. It's called mydisabilityquestions.com. You can go to that website anytime you like. If a question comes to your mind, I want to ask James, I want to ask Savannah, a member of the crew. You can type it in there, and before you click send and have it logged in for someone to look at, there's also a searchable database, meaning that your question may have been asked in some way, shape, or form previously. Save you some time. Read the answer. If not, leave it there, and a member of the team will get to it for you. mydisabilityquestions.com. James, in that regard, I want to get one from Scarlett. Says, my husband hasn't been the same since he was in a bad car accident years ago. He used to work as an executive at a large communications company. He was on long-term disability benefits, but was cut off in late 2019, and we never found out why. He's still struggling, and his doctors say he's in no shape to work right now. Is it too late to start a legal claim?
Well, so first, the good news. It's definitely not going to be too late. If your husband was cut off in late 2019, he is within the 2-year window. And so here's what I mean by that. When you are denied or cut off your benefits, you have 2 years from the date that you are notified by your insurance company, formally notified, in order to start a legal claim. If you don't bring a claim within that 2-year period, you don't have any recourse. The courts are pretty strict about applying this, and so there's really virtually no way to get around this 2-year limitation period. But here's the thing. They're required to formally notify you. And so if they just say, oh, well, we called and we told Scarlett's husband that he was going to be cut off and we stopped paying, that's not going to satisfy the court that they were formally notified. What you need to do is actually send a letter. An email at this point would probably suffice, but it would have to be some written communication that very clearly states that the claim is denied and sets out what happens if they want to challenge that. And typically they'll invite you to appeal. Again, please don't. You want to start a legal claim. But that is what has to happen. They have to send you some sort of written communication, whether it's a letter by mail or by email is probably both fine. It doesn't seem to have happened here. Now, it is possible that it was sent and somehow lost in the mail, almost 2 years ago. But whatever the case is, even though there may be an argument that the insurance company in this particular case is, that the 2-year limitation period started when they cut off the benefits, if they can say that we did actually send this letter and you didn't receive it, and if a court accepted that, even if they could do that, you still are within the 2 years. So you don't want to mess with that. You want to start the claim as soon as possible. And that's exactly what you should do in this case.
And I guess he's got the backing. If this comes to fruition and it's accepted, his doctor is saying he can't work right now as well. So that's good too. That's great ammunition to get him on claim, no?
Yeah, that's always the first thing that we look at. Whenever someone contacts us, the first question I always want to answer is, what are your treating doctors saying? And if your treating doctors are supporting that you're not able to work, then I'm going to have confidence that there's a claim there. And that's exactly what Scarlett is telling us is the situation with her husband. His treating doctors are telling him that he's not able to work, even though he was cut off his benefits, a year and a half ago. He's still not able to work. So I have confidence that this is going to be a successful claim.
All right, pal, let's move on to an email, help@disabilityrights.ca. That's the way you reach out to James and his team through email. This one today right now is Alice. Alice says, I went off work due to workplace harassment. With my psychiatrists and psychologist support, I was eventually approved for LTD. I'm now almost at the 2-year mark of my leave. The insurance company is now requesting that I go through an independent medical assessment. Do I have a choice in attending the assessment? If my claim ends up being canceled, do I really have to go back to an abusive workplace? Okay,
so 2 very different questions here. So first, let's talk about what happens when an insurance company asks that you go for an assessment. So while you're on claim, while they are paying your benefits, the insurance company has a right to have you assessed by a qualified doctor. And they don't have to rely on what your treating doctors are saying. If they want to get an opinion from someone that they choose, they are entitled to do that. If you've brought a legal claim or if you're under benefits, they are certainly entitled to get someone that they trust and rely on to provide them with an opinion. So unfortunately, if they have told you that they want to have you assessed, unless it's someone who isn't qualified, or if the assessment is for something that's totally irrelevant to your claim, then you really don't have any argument. And if you refuse to go, you can bet your insurance company is going to cut off your benefits, and they would be justified in doing it. A court would say that they were correct in interpreting it that way. You do have to submit to a reasonable assessment by the insurance company. Now, the second part is something that's, certainly a very different situation. And so what Alice is asking is she going to be forced back to her old job, which was a difficult situation for her, and I think she said that there was harassment there. Yep. And the answer is absolutely not. The insurance company, first of all, doesn't really care whether you go back to work at all, or if you do go back to work, if you go back to your old job or to a new job. It doesn't matter to them a bit. All they care about is whether or not they are paying you benefits and if they have justification for cutting you off if they decide to do so. That's it. So if they are to cut off your benefits, if the insurance company goes through that assessment and the assessment comes back and says that you're able to go back to work, well, that does not mean that you have to go back to your old job, not at all. You are free to go back to whatever job you would like to do, and that's absolutely what you should do, especially if your old work situation is abusive in any way. Obviously, there's no reason that you should ever do that. And it's not unusual for someone in this situation, when you're approaching this 2-year mark after you've been receiving benefits, to have an insurance company react in this way, to start sending you for assessments. And the reason they do that is because at the 2-year mark, once you've been getting benefits for 2 years, the test that the insurance company uses to determine whether or not you're entitled to benefits is going to change. For the first 2 years, the test is whether you have a disability that prevents you from doing your own occupation. After 2 years, that test changes to whether you have a disability that prevents you from doing any occupation that you're qualified for by training, education, or experience. And so it's a broader test. It's a little more difficult to meet for sure. And so it's not unusual for insurance companies, when that 2-year mark is approaching, to see them trying to build up evidence in order to support a conclusion that even though you might not be able to go back to the job that you had or the occupation that you had, there is another occupation out there that you're able to do.
MyDisabilityQuestions.com. I think we got time, James, for one more of these, so I'll serve it up to you. This time it's Trevor. Says, I've recently been placed on LTD. I was diagnosed with generalized anxiety disorder and OCD. I've managed with the help from my doctor and my therapist. My insurance company is now asking that I see one of their psychiatrists and start a new treatment plan. I feel that my doctor and therapist have been very helpful in treating my disorder. Do I have to follow the insurance psychiatrist treatment instead? Different animal.
Okay, so first of all, this is a really, really tricky scenario, and I want to make sure that you understand my answer here. So first of all, a psychiatrist's opinion is going to be preferred by a court when you're talking about a mental health issue over that of your family doctor or over that of a therapist. Seeing an MD, and particularly a specialist in mental health issues, is going to be preferred. But having said that, even though the insurer psychiatrist may be preferred, and even though their opinion about you requiring ongoing treatment from a psychiatrist may in fact be what the court determines is reasonable, that doesn't mean that you have to get that treatment from their psychiatrist or from anyone else the insurer sends you to. Even though it may be reasonable that you have to go and get this treatment, you can choose who you get the treatment from, and that's exactly what you should do. You should never just accept treatment from the insurance company because they've pointed you in this particular direction. And the reason should be obvious when you think about how that person is getting paid. If the insurance company sends you to a particular person for treatment, they're paying for it. And what that means is if a person is getting a paycheck from an insurance company, at the end of the day, they know who they have to satisfy. And even if they are not approaching it with a conscious bias, that is going to underlie their decisions because they know if they return too many opinions that are unfavorable for the insurance company, eventually they're going to see that work dry up. And that's something that is going to seep in for most people into their opinions. And so whenever an insurance company says, okay, you need to get this treatment and here's someone you can go to, well, first ask yourself whether you need to get the treatment. That might be justified in this case, it might not be. I'm not qualified to actually determine that. But assuming that that treatment is in fact necessary, don't rely on the treatment provider that they are suggesting to you. Go to your family doctor and have your family doctor refer you to someone who's going to be completely neutral and who your family doctor trusts and relies on and thinks is more than competent to deal with your issues. That's going to put you in the best possible situation. And the insurance company can't say, oh, you have to get treatment from this particular person. If they were to deny you on that basis, then more than certainly a court would step in and say, no, you're not entitled to do that. You can't tell someone who they have to get their treatment from, only that they need to get reasonable treatment in order to satisfy the terms of the policy.
Give me 30 seconds. You mentioned MD has some weight, especially in court or otherwise. Just give me 30 seconds on why sometimes a consultant, whatever that is, may not have the same type of effect.
Well, in this particular case, it sounds so the insurance company hired a doctor, a psychiatrist. But oftentimes, you'll get opinions from an insurance company where they say our medical consultant says this or that. If they say medical consultant, it usually means it's not a doctor, and it's often someone who doesn't have the expertise that you would really think is necessary in order to give an opinion, particularly about complicated medical situations.
If that's something that you guys fear a little less or will take a little more time with, not fear, you don't fear it at all. I'm just saying, is that a little easier for you guys to traverse?
The reality is we rely very heavily on the treating doctors, and for good reason. When these cases get to court, and it's very unusual, but when they do, the courts show much more preference to the opinion of the treating doctors and specialists than they do to anyone hired by the insurance company to provide an opinion.
You want more information at any time? Now that we are done, simple. Reach out to James, 1-855-821-5900. The phone number, we have it up at the bottom all the time. help@disabilityrights.ca is the email address. Just Disability Rights is where you can find our radio show, that website, and mydisabilityquestions.com as well. We'll catch you next time, Disability Law Show.